Welcome back to the deep dive. This is where you bring us the source material, and we jump right in to find those crucial insights just for you.
Yeah, we help you sort through it all, find what really matters and, why it's important.
Exactly. And this deep dive, it's part of our ongoing series looking at the Manual of Patent Examining Procedure, the MPEP. We're kind of breaking it down section by section.
Today, we're hitting the basics, the really foundational stuff about getting a patent application actually started and filed correctly with the USPTO. Think MPP Chapter 600, specifically Section 601, focusing on what actually needs to be in provisional and non-provisional applications.
Right. So our mission here is to cut through all the jargon. What does it really take to get that application officially filed? What gives you that filing date? What are the pieces you need? And maybe most importantly, why does getting this stuff right at the very beginning matter so much later on?
It really is like laying the foundation for a house. If that's not right, everything built on top is shaky.
Okay, before we dig in, just a quick special thank you to Mike Shepard, our creative director, for putting this whole audio series together. Right then, let's start at square one. What's the absolute bare minimum you need just to get an official filing date for, say, a non-provisional application? The sources mentioned 37 CFR 1.53b.
Okay, yeah, this is super important right out of the gate. For most of those non-provisional applications, the main kind, under 35 U.S.C. 111a, the filing date is basically the day the USPTO gets a specification, and the sources are clear. This can be with or without claims.
Hang on, so you say you don't even need the claims, the part that defines the invention on day one, just the description.
For the filing date itself, for a utility application, that's right, the specification, the written description, that's a core element needed to lock in that date according to Section 601 and the rules.
Okay. What about drawings? Are they always needed for the date?
Not always. But there's a big exception mentioned, design patent applications. For a design app, Section 601 is pretty clear you need the specification, at least one claim, and any required drawings, all received together. That's different.
So spec is always needed for the date. Drawings are non-negotiable for designs, and claims, surprisingly, can wait a bit for utility apps. And that filing date, once you get it, that's a big deal because a critical rule quicks in immediately, doesn't it?
Absolutely. The moment you secure that date, 37 CFR 1.53b hammers this home. No new matter. You cannot add anything substantive to the disclosure after that filing date. It establishes the scope of what you originally invented as of that day.
The sources also mention provisional applications. They're not examined like non-provisionals, but they fit into this early stage somehow.
Yeah, they serve a different strategic purpose. Think of them as a placeholder under Section 111b. You file a specification, and any needed drawings, again, per Section 601, pay a fee, and you get a filing date. But you don't need claims or that formal inventor's oath right away.
So a simpler way to get a date on record.
Exactly. It gives you 12 months to decide whether to file a full non-provisional. The sources mention things like how an abandoned provisional might become public if you later reference it, and that they have their own process for, say, correcting who the inventors are. But importantly, they aren't examined, and you can't claim priority from another application to a provisional.
Okay, so getting the filing date is step one. But that doesn't mean the application is ready for the examiner yet. What else needs to be in the full package?
Right. A complete application for examination needs more. You've got this specification, obviously, that detailed written description we mentioned.
And the claims, even if not needed for the date for utility apps, they become essential, right? That's what defines what you're actually trying to protect.
Precisely. And, the sources touch on how claims get interpreted later. There are these warnings based on case law, like Superguide and Label Flartime, about not improperly reading limitations from the examples in your spec into broader claim language. The claims need to stand on their own.
Makes sense. And the drawings provide the visual side.
Yes, and they have rules too. They need to show everything necessary to understand the invention. The MEP talks about handling objections to drawings, how to label replacement sheets correctly if you need to fix them. For designs, there are specific conventions, like using broken lines for parts you aren't claiming.
Then there's the paperwork from the inventor themselves.
The inventor's oath or declaration, generally required for non-provisionals under Section 115, as outlined in Section 601. The rules do allow for substitute statements if, say, an inventor isn't available or refuses to sign, but there are strict conditions.
What about for international applications coming into the U.S.?
Sometimes you can delay filing the oath for national stage applications if you provide the inventor's details correctly on something called the application data sheet or ADS, but you'll definitely need it before certain steps, like requesting continued examination. The oath is also key for confirming inventor names and citizenship, resolving any conflicts with the ADS.
Okay, you mentioned the application data sheet, the ADS. What exactly is its role? Sounds important.
It really is. Think of it as the application's main information sheet for bibliographic data. It's become central. It's where you make really crucial claims, like claiming the benefit of an earlier U.S. provisional or non-provisional application.
And for foreign priority.
Yes, and this is a big one highlighted in the sources. For any application filed on or after September 16th, 2012, you must claim foreign priority in the ADS. Before that, you could sometimes do it in the oath, but now it has to be in the ADS. Missing that can be a major problem.
Good to know. And of course, patents aren't free. Fees are involved.
Definitely. There are the upfront filing, search, and examination fees needed just to get going, as mentioned under Section 111. But the sources also remind us about later fees, publication fees, and those maintenance fees to keep the patent enforceable years down the road. Even specific actions like fixing inventorship on a provisional have their own fee.
The sources also seem to spend a lot of time on special content, like sequence listings or large tables, biology and data-heavy inventions.
Oh yeah, that's a whole complex area. MEP Chapter 2400 covers this, but Section 601 touches on the need for compliance. There are very specific rules about format like ASCII text versus XML, depending on the filing date and sequence type, ST.25 versus the newer ST.26 standard, how you submit it electronically via EFS web or maybe on a read-only optical disc if it's huge.
Size limits, too.
Yes, there are size limits for electronic filing, like 100 MB for ASCII text sequences. Bigger than that, you might have to use disks. And crucially, if you submit these electronically or on disk, the main specification has to include a specific incorporation by reference statement pointing to that electronic file.
And what if you need to change it later? Amend the sequence listing.
You usually can't just tweak it. You have to submit a whole new, complete replacement sequence listing. And with that, you need specific statements confirming no new matter was added and that the changes are fully supported by the application as originally filed. It's quite procedural.
Okay, so we have all these parts. But who is actually the applicant? The sources say it's not always the inventor.
Correct. That's covered in rules like 37 CFR 1.42 and 1.46. While the inventor or joint inventors are the default, the applicant can also be an assignee, the company or person who owns the invention rights, or someone who is legally obligated to assign it, or even someone else who can show they have a sufficient proprietary interest.
And if the assignee wants to step in or take control.
Right. If an assignee wasn't the original applicant but wants to, say, prosecute the case or change attorneys, they generally need to prove their ownership to the USPTO according to Rule 3.73. The sources mention things like how an officer signing for a company assignee is usually presumed to have authority. Getting this right determines who can actually interact with the office.
Which ties into who appoints the patent attorney or agent, the power of attorney.
Exactly. Generally, only the official applicant or the patent owner can appoint or revoke that power. So an assignee needs to properly establish themselves as the applicant first before they can change the representative. Though the sources note that a practitioner named in the initial filing papers might be able to handle some things, like updating the correspondence address before a formal power of attorney is filed.
And the correspondence address, that's just where the USPTO sends everything.
Yep, all the official letters, the office actions, everything goes there, so keeping it current is absolutely vital. You can also set up a separate fee address just for maintenance fee reminders, which can be handy.
Okay, let's shift gears slightly to leveraging earlier work. Why is claiming priority or benefit to an earlier application so important? What's the point?
It's all about getting an earlier effective filing date for your invention, or at least parts of it. That earlier date is what the examiner uses when comparing your invention to the prior art patents, publications that came out before. A claim that gets an earlier effective date might be patentable over art that would otherwise block it.
And there's a difference between claiming benefit to a prior U.S. application versus claiming foreign priority.
Yes, the rules and bases are different. Claiming benefit under 35 U.S.C. 120 or 121 is for linking to earlier U.S. applications, like a provisional or making continuations or divisionals. The key requirement there is putting a specific reference to the prior application in the later filed one, usually, again, in that application data sheet, ADS.
Okay, and foreign priority.
That's based on 35 U.S.C. 119, linking back to an application you first filed in another country that's part of an international treaty. The timing here is really strict.
How strict?
Generally, you have to file your U.S. non-provisional application within 12 months of the foreign filing date, 6 months for design applications. Miss that window, and you typically lose the priority claim entirely.
And that's not all, right? There are deadlines within the U.S. case, too.
Correct. Just filing the U.S. app in time isn't enough. You also have to formally make the priority claim within the U.S. application by a certain deadline. That's usually the later of 4 months from the U.S. filing date, or 16 months from the foreign filing date. If you miss that deadline, the claim is considered waived.
Ouch. Can you fix it if you miss it?
Sometimes. You can petition to have an unintentionally delayed claim accepted, but it costs money and adds complexity and uncertainty. It's much better to just meet the deadline.
And you need proof, right, like a copy of the foreign application.
Yes, you generally need to submit a certified copy of that foreign application. And guess what? That has its own deadlines, too often linked to the U.S. filing date or national stage entry date. Again, you can petition if you're late, but it's another hurdle. And remember, for apps filed from September 2012 onwards, that foreign priority claim itself must be in the ADS.
Seems like the ADS is popping up everywhere as critical.
It really has become the central document for a lot of these crucial declarations and claims.
And the sources mention international applications, too. PCT and Hague designs entering the U.S. Similar priority issues there.
Yes, they have their own specific procedures for entering the U.S. national stage and making sure any priority claims are properly carried over and asserted according to U.S. rules, like ensuring the submission is clearly identified as a national stage entry.
Okay, wow. We've walked through a ton of detail about what goes into that initial application package, from the bare minimum for a date to all the parts, the applicant, the priority claims. Let's tie it all together. Why does sweating these details at the start matter so much for the rest of the patent journey?
Because fundamentally, everything that happens later, examination, amendments, potential challenges, it all builds on that initial filing. Getting the requirements right, like those in MPP Section 601, right from the beginning avoids so many problems.
Yeah, what kind of problem?
Well, obvious ones are delays and extra costs. If your application is incomplete or has defective drawings or misses a required fee, you'll get notices from the office. Responding takes time and effort. If you don't respond correctly or on time, you risk the application simply going abandoned.
And the applicant identification and ownership stuff.
Absolutely critical. If there's ambiguity about who the applicant is or if ownership isn't properly established, you might find out later that the wrong party was prosecuting the application, or that you can't enforce the patent because the chain of title is broken. Keeping the correspondence address right means you actually get the notices you need to respond to.
And those priority claims we spent time on.
Probably one of the most critical areas. Getting your benefit or foreign priority claim wrong, missing a deadline, not making the claim correctly in the ADS can mean losing that earlier effective filing date. If relevant prior art emerged between your original filing and your later one, losing priority could mean your invention is suddenly judged unpatentable over that art. It can be fatal to the application or invalidate an issued patent.
So it really impacts patentability directly. Does it echo even further down the line, like with patent term?
Indirectly, yes. The Patent Term Adjustment, or PTA, system compensates for certain USPTO delays, but it also reduces that adjustment for delays caused by the applicant. If your initial filing was messy and led to back and forths and delayed responses, that could chip away at any PTA you might have gained. Everything stems from that initial foundation. Even later things like re-examinations or appeals rely entirely on the record created, starting with that first filing.
Even the provisionals we mentioned earlier, if you don't examine them, but you reference one in a later patent.
Then that provisional application file can become publicly available. So even decisions made about those early, seemingly simple filings can have long-term consequences. Diligence from day one, following the rules in sections like Section 601, is just essential.
Whew. Okay, so we've really dug into the bedrock rules for getting a patent application filed MPP Section 601 territory. From the absolute minimums for a filing date, through all the necessary components, spec, claims, drawings, oath, the critical ADS dealing with special content, figuring out who the applicant is, and the huge importance and tricky rules around priority and benefit claims.
It's definitely technical, maybe a bit dry sometimes, but mastering these initial steps, understanding what the USPTO requires right at the beginning, is absolutely fundamental. It's how you build a strong foundation to navigate the whole system and hopefully avoid major issues later.
In this deep dive, focusing on rules around initial filing content, like in MP Section 601, is just one slice of that huge MPP manual.
It really highlights the level of precision the system demands right from the very start.
So here's something to think about. We see all this meticulous detail, these strict procedures designed to make sure applications are complete and claims are clear. How does this structure, which aims to protect inventors and the public by ensuring quality, simultaneously act as both a necessary safeguard and potentially a complex barrier that might, slow down or challenge the very innovation it's meant to foster?
That's a great question. A real tension there between rigor and accessibility.
Definitely something to mull over. Now, just our stunned reminder. This summary of the MTEP was put together using AI tools, including ChatGPT and Notebook LM. It might have errors or leave things out. It's really just for general educational info. It's not legal advice.
Please always consult the official MPEP itself, or talk to a qualified instructor or a registered patent practitioner for guidance on any specific situation.
Thanks so much for joining us for this deep dive. We hope you feel a bit more grounded in the essentials of starting a patent application correctly.
Until next time.